Welcome back. This is Newsfile, it's your most authoritative news analysis show, and here on Newsfile we put Ghana first. Thanks for all your comments and your questions that have been coming through. Now, there are some of you who are asking Honorable Yunus Afuseni that you cannot blame any journalists who went there to Hohoi and Hohoi people for expressing themselves the way they did, because the president said Hohoi Township roads, and so that's it. They just did their work. And
but no one blame journalists.
Okay.
No one has said that here.
And Abbas is asking, how are we to verify the president's claim that 45,000 pupils have been enrolled in basic schools as part of the government's FQ policy? Every year, pupils are enrolled in schools. Please ask Inusa how we can check these figures the same way as we are checking the Zinabu and her picks, especially giving that government's figures. Okay. Okay, got a few more messages, but we have very limited time to deal with a few of the other issues that are coming in. So pardon me if we move on to those ones. This one from Kofi Chumbuafo. He says the whole Ghanaian political system needs overhauling. In many developed countries, people go into politics to serve and gain experience with which they make money when they exit the political stage. The reverse is the case in our country. I hope the next MPP government makes it difficult for these charlatans to steal from the state. I see. Okay. Now let's see if we can say a few things about the spy bill. Why are we calling it spy bill? Initially, there were some naming to it: eavesdropping bill, snooper bill, or so to speak. And now, spy bill is taking all over the place. Interception bill. Right. Now, okay, Kofi Bento has views that are already known, but of course he's put them rather in a more summarized manner. He'll share them with us shortly. Yunus Afuseni, you've heard him also say a few things about it. I'll start with Abdul Malik on the spy bill. My question is, you at the last time also suggested that this may not be a necessary thing to do. Question to you and to all of you here who are against this bill. What is your biggest fear?
Well, at the risk of repeating what I said the last time, I mean, that might bore some people. I think the key area was where the public officer or the security coordinator is given a certain unimpeded, space to order the interception before subsequently bringing it to the attention of approval of the court.
Yeah, 48 hours.
Yes.
And he can
right.
do that unlike even the president were in section 100 of the Electronic Communications Act, where he's required to do so by written request. The National Security Coordinator can do that orally.
Yes.
That's your fear.
Yes, I think that's where many people are worried. Because if you remember, I made the point that for me, the risks exceed the risks in the other legal regimes. And I quoted from the Anti-Terrorism Act last time. So that's why I was a bit intrigued that there was now a more heightened awareness, because that risk is always there.
So your biggest fear is for the interception to be done without recourse to a court?
I think it's a problematic.
Prior recourse to a court?
Yeah, I have a problem with that, instinctively. I mean, and I would be surprised if there's any human being out there who doesn't feel that way. And if you think, well, you see, perhaps if you think you are in office, so you are protected, make no mistake. So I have a problem there. Otherwise, the way the world is going and changing, we need some, instruments to do certain things. But let's do it in terms of the law and looking at human rights, looking at privacy. And we are not incapable of crafting something that will be acceptable.
Just take out
to everybody. Yes, that's my view.
Okay, very brief. Kofi, from where he leaves off, tell me, with intercepting your communication, you are okay with it only if it is done with the approval of the court. But have we thought of situations where there is real emergency? Going to the court, certainly a problem.
Well,
what about Saturday? What about a Sunday?
Right. So sometimes the impression is created that going to the court is the normal process that takes forever. This process is not like that. It's just like the Public Order Act. You have to present the written request before a judge. Any time of the day, any day, including Sunday at midnight. So one, the issue of emergency and the access to the courts really doesn't rise because it's a special one. And indeed, furthermore, judges can be appointed specifically for this, so you know exactly where to go.
Okay.
All you need is to present this in front of the judge. You can wake them up at midnight on Sunday and do it. Because if it's national security, it is that serious. So all that complexity goes away. Okay. Now, why, therefore, do you need to take that away? We need to know that we are purporting to tamper with a fundamental human right. And it's not a simple thing. You see, 4,000 years, I keep saying, of the development of mankind and democracy have come to prove that when you hand a man born of woman a certain power, they are prone to misuse it and slide the whole society down with it. A woman found her husband standing in front of their TV with a stick. And it looked like he was going to hit the TV. I said, what are you doing? He says, there's a fly on the TV, I'm going to kill it. And the woman said, but you spoiled the TV. He says, no, I'm very skilled. I can hit the fly and not spoil the TV. Picture that. That's exactly what they are doing here. That they can wield this power and not abuse it and not cause trouble. I give you just one example again in the procurement bill, where they have elevated a small pinhole to the main thing. I'm simply saying this. Me, I don't have anything to hide.
Sole sourcing.
Sole sourcing. That small pinhole has been elevated to defeat the law that was actually made so that sole sourcing would not come.
See.
So they should pass it but take out this.
Is there a record of the security officers seeking to get the warrant from the court and having problems?
There is no known record of difficulty.
So if there's no record really, and they will be granted anyway, why don't you let them do it without recourse to the court?
Again, it's intriguing. The fact that there is no record of they being denied does not mean they will always be granted. Note something. When
they
you
go ex parte, they always go alone.
Which is okay. I don't object to that. But it does not mean the judges, excuse me, don't have brains. If you go to the judge and you don't make a good case, she will deny you. And if they continue, if the judges don't do their job or the system breaks, and in the Public Order Act, something interesting has happened. You may be aware that we're going to go to court on the Public Order Act because of how the police were treating it, going to circuit courts and obtaining, you know, that order.
Yeah.
Guess what happened? Because that thing was abused, even though it was legal, it got to the point the Supreme Court just struck it down. So if they go and the judges refuse to scrutinize the request and they start abusing it, the system is there to kill it.
Did you say Supreme Court? This was Justice Dennis sitting in the
Dennis.
High Court,
Yes.
Human Rights.
Yes, Justice Dennis did it. So you see, when there is a system for self-cleansing, it works. Here is a bill, and I've told everybody, and check. The only unique thing about this bill is that it removes all requirement for permission and removes all risk of punishment if they misuse and abuse it. And Kweku told us the last time that there are even others that seem
but
worse.
is that statement correct, that it removes the risk of punishment? Because there are clear sanctions, including prison terms.
Listen, the prison term is about when you have intercepted and you have disclosed the information to somebody in an unauthorized way. That's not the risk. The risk is the person listens to you for 35 hours and then stops. So they haven't broken the rule. They let one day pass. They listen to you again. And then it turns out that all the time they were listening to you, it was not for national security, not for terrorism, not for anything. In other jurisdictions, what you find is that after, let's say, 3 years of operation, they bring every single case of interception to a panel for review. And they are able, after a time, to publish exactly what happened, including the names of people who were interfered with. And where the thing was not properly done, the people have a right of redress. None of that is here.
You must be familiar with the Patriot Acts of the U.S.
Yes.
Passed in response to 9/11. How different is this from that?
Indeed, America is the most intrusive democracy in the modern world.
That's true.
They do it more than anybody. But even in America, today, Apple is in court, resisting the government's instructions to do certain things. Because certain societies clearly are better developed in terms of the defense of liberties. They have layers, okay? So even with the Patriot Act and what it stands for, in America, you cannot just get up and go and infringe on people like that. And if you do, and it turns out that what you did was wrong, everything will break out on you. We are simply saying, have that here.
Okay.
I will agree for this law to be passed if they take out section 4.3, because in Malone it has been stated that for it to be lawful, it must not give unfettered power.
Okay.
And for it to be lawful, it must have sufficient protection. And then please make sure that there is a review mechanism.
No, but if you say that, you say this is unfettered discretion,
It's unfettered.
then section 100 of the Electronics Communications Act, I say the group that did it is very ingenious work. They said in some emergencies, the president has the power to do what we are now trying to give to the National Security Coordinator.
By EI.
So what's the problem?
By executive instrument.
What's the difficulty in promoting an executive instrument?
Good, so let them do it here, because you see, the president will therefore have to contemplate and write down and issue some instrument, and it goes into the record. That becomes what you hold on to if your rights are
That is still the president intercepting your communication without recourse to a court.
But then they have to go through a certain process that requires them to pass an executive instrument, and that instrument itself goes through a certain process. So all we are saying is that this unfettered power, oral, wake up, decide that I want to listen to Inus Afuseni, and it's not just the National Security Coordinator, any public officer.
Right, public officer.
Okay, you can imagine somebody
very
paying somebody to
aspect
trace
of that law.
So they should just put in the proper safeguards, and this thing will pass.
Okay, as far as you are concerned, they should remove section 4.
4.3.
Section 4.3.
Yes, and subject themselves to the judge.
Okay, thank you. But he talks about a process in going through to get an executive instrument done. Is that really difficult?
Well, that's really difficult. That's not difficult actually. The president can do it, but he has to do it on certain conditions.
No, yes, but I mean, tell us if you are aware of how an executive instrument is done. Tell us what trouble will he go through when he wants to, issue an executive instrument.
Well, again, you'll be advised by the national security, the minister responsible for security, on the need to do certain things. Then, because executive authority is vested in the president,
is it referable or reviewable by Parliament?
No, it's not.
So.
But the record is there.
The same thing.
No, it's not the same thing.
So it's easy. They should do it.
So they should do it. So let me tell you why it's not the same thing.
Yes.
And again, let's start it this way. Is this legal regime already part of our legal regime in certain aspects of preventing crime? I say yes.
Yes, it is.
It is.
With safeguards.
No, it is.
With safeguards.
With safeguards. That's
this
correct.
particular provision has safeguards. No. It is not unfettered.
4.3 is unfettered.
You see, read the Constitution and read the law.
Which part of the Constitution?
Article 296.
Or 296. What does it say?
Discretionary power. You are talking about discretionary power. Duty to be fair and candid. Okay? That's a duty. Reasonable. Not to abuse the discretionary power. The London hospital case, read it. You will realize that if I'm listened to and I have strong reasons to believe that this discretionary power has been abused, I go to court.
How will you go to court if the order was by an oral order?
Again,
you have no prima facie evidence of what you have to take to court.
Evidence, how do you even know that you are listened to?
Okay, and is that not also a danger?
That's not the danger. The danger is that man is directing, the National Security Coordinator is directing the telephone service provider to provide facilities for the national security apparatus to listen and track the conversation or the postal packages of X, Y, Z. Because under law, the law of privacy, and that's why I'm surprised that Nana Akufo-Addo waded into this thing. Because the senior lawyer should know.
He says he will not pass it.
He says it's a spy bill.
He will rather pass the right to information law. But Abang Babing announced in Parliament, yesterday, that they are at the
296.
right to information bill and they will pass.
He
it.
cited 296. Let's read it. It says the exercise of discretionary power shall not be arbitrary,
Yes.
shall not be capricious,
Yes.
shall not be biased,
Yes.
whether by resentment, prejudice, or personal dislike, and shall be in accordance with due process of law. Due process of law has been defined in a constitutional regime to include proper safeguards. Now,
That's
this
the
thing
proper
says,
say- no, that's
Okay.
the count.
an oral instruction is
You're talking
It's arbitrary. I think I will support you.
You're
Let's
talking
go.
about the
An
good law.
oral
You're talking
instruction
about
is-
the basic
it's okay.
law
Hold
of
on,
the
hold
land.
on. Yeah.
You're talking about the basic law. Should not be capricious, should not be arbitrary. Okay?
Oral is
So
arbitrary.
it comes back. How do we ensure that it doesn't become arbitrary? The law tells you. The law tells you that
the
even
oral
if you direct the telecos and the
It's a
telecos
dangerous
do the tapping, you have to report because you now are going to talk to a third party. The National Security Coordinator.
You have to
probably-
report to who?
You have to go to court. For
You see, you can detain and listen to whatever it is, and then go to court to confirm within 48 hours.
Hours.
He's telling you that there is some room for abuse. I listened to you for 43 hours. I listened to you for 47 hours.
and withdraw.
Then I stop.
The law is saying that you
I
listen,
stop.
when you listen within 48, the law is not saying that listening for 48 hours before you
Or
go to
within the period.
go to court.
So I make sure that I
another-
listen to you, but I don't go because I don't need to go.
And nobody knows.
You have to. No, the law is saying that anytime you issue, read the law carefully. The law, if you reading laws, you must read it in favor of protecting the rights. The law is actually saying that anytime you issue an oral order, within 48 hours, you must go to court and confirm it. That's what the law is saying.
mean
How
the
do you
bail.
document an oral order?
The bill, yeah.
The bill.
The bill.
The
not
bill.
law.
Yeah.
That's what the bill is saying.
That's what it
the
means.
bill is not saying that when you listen to and it's not 48 hours, don't go to court. That's not
How
what
do
the
you
bill is
document
saying.
an oral order?
That's not what the bill is saying. Please.
How do you document
You
an oral
have
order?
to read the bill carefully to understand the intendment of the proponent of the bill.
Read it through.
You see, because why will you think that the egregious invasion of the fundamental rights of a person can be allowed to continue without safeguards?
How do you document an oral order?
You can document it because the National Security Coordinator is not going to the telecos to connect wires and listen to. It's not going to do that.
How do you?
He's
document-
going to direct.
The telecos risks having a problem.
Yes.
If they are not able to show any evidence of the oral order.
So the
With
telephones
their
telephones
clients.
say, well, we will provide you the facility, but we need a court order. The National Security Coordinator says that there is information in transit.
Yeah.
We need to be able to intercept whatever discussions are going on now. The law says within 48 hours after giving that order, go to court for ex facto confirmation of that order. That's a fetter on that power.
It's not.
You see, it is.
Especially
It is
when you
not
have
a
an
fetter. What is it?
ICH.
If
When
it's
you
not
have
a
an
fetter, what is it?
ICH,
Hold on,
it's
hold
not.
No, if it's not a fetter, what is it? It's a fetter. It means that
Have you
cannot.
have you become aware and have you been told? Of
Yes.
course, you're a lawyer. You have been familiar. You've been in private practice for a
that's the
considerable
factor.
period. No, where the former SFO or now EOCO,
Yeah.
where when it comes to your finances,
Yes.
the FIC, is it
Yes.
Financial Intelligence Center or
Center,
something?
yeah.
They are able to, place a hold on your accounts.
Yes.
They block it
Yes.
because they suspect that there's somebody
There's fictitious transactions.
something.
Yes.
Now, when they report, they hand it over to Yoko or something. They do it first by simply writing to the bank and
Yes.
asking them to block your account. Then they are supposed to go to the court and confirm
Confirm it.
within 7 days.
Yes. But this one is even 48 hours.
But when they do that also, now that's the point they have to give you notice that this is what is going on.
Go on. Yes.
Have you become aware that that law has been so abused that they do it without regard to anybody?
Yes, so you see, and that is why a democracy and the respect for the fundamental rights of persons thrive when citizens are vigilant. So when they abuse it and without more, then I go to court on the basis of the 296.
In respect of your account, you will get to know your account has been blocked.
You try.
But here, when he does it orally, how do you get to know that you have even been listened to so that you can go and assert your right?
Oh, the telecos will know.
With ICH,
telecos
you
will
don't need
know.
a telcos.
The telecos will know that you have been listened to, and the telecos are providing you a service. So what the telecos are fighting against is to insulate themselves against prosecution. That's what they're fighting against.
So
it's not you.
Because you have decided to listen to me.
So when you finally
the telco should come and tell me that you have listened to me.
So telcos are trying to say, look, they're trying to, somehow protect themselves and say, look, we want a court order. Because when I finally get to know
But that's the
that
point
I have been listened to,
Exactly.
the person I sue
Once
is the
they have
telco.
this law,
Because
they don't
I
need
have
a
a
court order.
contract with the telco to provide me with a service.
They told them to
Okay?
do this law.
So
They
you
tell
might
them
not know,
without a court
but
order,
you
they can't
eventually
give you access.
you will get to know
There's a
because
law that says
if
they have
the
the right to
evidence,
listen.
if for
They will
instance,
let you listen.
the evidence
And
now
then
becomes an evidence
their defense.
that will lead to prosecution.
That's why they put the
Okay?
there.
Now, if you the
this
evidence leads
removes
to
the
prosecution
re-
and you are sent to
re-
court,
re-
you will definitely know that you were listened to. That will clearly expose the contractual obligation between you and the service provider.
There's a technical error there.
I see.
Let me
Okay,
explain.
so that I have known. So why did you provide opportunities for XYZ to listen to my conversation with that Malon's case? Malon's case. How did he get to know?
In my
So-
petition that I took to the speaker and all the people who are concerned.
Yes.
I copied the majority, the minority, the ranking member, and the chairman of the committee, and told them that that petition represented my memorandum to the process. I'm sure you may have become familiar with it. Martin Amidu has written. Ace and Kuma, together with others, have also written. I'm aware that the Bar Association
We
is
didn't
also.
support you too, but we haven't written.
Thank you
CDM
very much.
supports you.
Is also putting in something.
Yeah.
I have listed only 5 laws.
Yes.
Okay.
Yes.
In which these provisions already exist.
As
But all
except-
those provisions require a prior approval of the court.
Yes.
Why do you want to circumvent
We're not
supervision?
circumventing. There's a lacuna. We're closing the lacuna. We're not
Which is
circumventing.
the lacuna?
Lacuna is that goods, communication in transit, goods, packages in transit. By the time you go to court for approval to intercept, the goods would have passed. How do you close it? How do you deal with the lacuna?
Benjilo, they
That
seized
is it.
his poster.
In fact, that's why I'm saying that the legal
Yes.
regime
Seized
already
goods.
exists.
He can't hold your-
That is why
Police can't-
we have checkpoints.
What if you are told this, that prior to around after
Who
after
presented
after
for
after
voting?
1990 or thereabouts,
Yes.
Benjilo,
Benjilo.
he had this sort of interception of his seizure of his goods, so to speak,
Yes.
through listening through his
Without the law.
conversations.
Yes.
It was done.
Yes.
Admitted in court.
But it was wrong.
You didn't need this
Okay, it
regime.
was
The
admitted
court,
in
the
court.
court admitted whatever has
court
been
admitted, but
intercepted
it was
for
wrong.
evidence.
It wasn't wrong. You can't sit there and say
wrong.
it's wrong.
Because you see, the
When you read the
admitted-
narcotics, the narcotic drugs and enforcement control, blah blah law, it allows the police even to do the work that ANAS does, to come and put cameras in your home and all of that.
Go into your house.
I'm saying that look at the law comprehensively. In looking at law, don't just pick and choose. I just gave you one example. You said there were no fetters on the power. I've just read 296, which is a fundamental fetter on
Well,
the
he
power.
disagrees
Let me
with
explain,
you.
Mr.
No. You
I
can't
can
decide-
explain right now.
You see, if a law is inconsistent with the Constitution, that law to the extent of the inconsistency
It's
becomes
void.
null and void.
That's
That's
why
why
he
I
says
go
if you
to
pass
court.
this
So
law,
when
you
you
go to court.
So you go to
Because
court.
as far as he's
Yeah.
concerned, it will not
So-
pass the
so you go to
constitutional
court.
master.
So you go to
Now
court
let me
and
bring it
demonstrate.
honorable.
You, in reading the law comprehensively, you have to also look at the evidence. Which evidence is admissible? Is there in the evidence decree? Is there a provision which says that when information is surreptitiously intercepted, is admissible in court? Is there a provision like that?
There's a provision similar to that.
No, which one?
The Blemezia case.
Oh no,
no,
it's not a
he's-
case.
he's
A
talking
provision
about
in
the Evidence
decree.
Act.
Act.
The practice in the courts have proven that evidence, no matter how obtained, is admissible.
No.
Please, the
court-
Blemezia case. I was taught by Bro
No. The practice in the court.
Practice in the
then
court.
say that they evaluate the evidence. The court will evaluate the
Relevance.
evidence, the relevance,
Oh, relevance
and
is another matter.
public interest against.
It's another matter.
Yes, so it's not that if no matter how it was known,
Relevant evidence, however obtained.
If the court says that we should fight him judicially,
You're familiar with that case. It matters not.
Relevant
Even if stolen.
evidence, however obtained.
Even if
It's
stolen.
admissible.
Yes, but the court laid down even if stolen. But the court laid down instances that it can be admitted.
Okay.
Let me
hold on. And then let me bring it.
Then we should fasten the courts.
Yes. Nanado has stepped in already.
Yes.
And he says that he will not pass it, and that it should not be passed.
Yeah.
Instead, he says he will pass the right to information law. Yeah. Now, Babwing, the majority leader, has come in to say that, well, they are already in the process of considering the right to information law, and they are likely to pass it. Some are suggesting that, of course, this is becoming a political, game, because the NDC wants to deny the NPP a political message, a campaign message, where it would have said, the right to information law has not been passed. Rather, you are passing this one. And so you are in a hurry to go and pass that. But again, Babwing suggests that they have had problems because of a number of amendments. The truth really is that these amendments have been done long ago. And they were expected to have been passed long ago. The committees that are on it have accepted all of these, have adopted them. So there's actually no reason why it is still being held up. Yes.
The reason why it was held up in the first place was...
Please, Senior, I have the floor. Excuse me. Yes, Samson, I've been schooled, and this morning, but before dawn, I've had a copy of your own and others, and you asked a very simple question. What are we afraid of, those of us who are against? The very things that you've enumerated here are still valid, and very valid too. So, I have another document here with me. This is written by Mazimus Ametogo. Yeah, he puts it so simple and clear.
He's a telecoms expert guy.
Yes, yes. And at this point, I want the ordinary man on the street, the taxi driver, the market woman there in Bantam.
It's not the market woman. They don't communicate, and they are not the threat. We
please,
know those opposed.
Please,
hold
let him make his point.
All laws in Ghana are meant for the citizens of Ghana. It is in the interest of the farmer.
Please, can we hear him?
And then we.
It is the interest of the farmer, the taxi driver, the market woman, to know what is going on. That is what we've been doing. We've detached governance away from the people, and we, the so-called leadership, we want to do what we want. I mean, at the blind side of the citizenry, and that is very dangerous. We have their mandate.
There are people who are saying, if you do not have any sinister motives, you want to get into committing crime, why should you be afraid of this bill?
Yes,
this law.
Yes, the ordinary man I'm talking about who want to have his or her privacy. I mean, engaging with a wife or a girlfriend or whatever, that at that simplest level, and somebody sitting somewhere, listening in
public official,
unofficially. I mean, that is it. That is an interest for the market mommy and the taxi driver.
Right.
He says, the expert says,
and you are reading Mama Ametogo's
yes, Ametogo's yes. He says the government simply want to copy, listen to your your conversations and all that. That is so simple. I mean, what is it then? All that we are talking about, interception and all those
unreasonable. The law
in any way, what is so much so hunting the NDC government at this last hour of elections? You wait till your 8 years, about 8 months to elections, and you want to come in with this controversial law. Is it to generate some more tension or what?
When people are bringing guns, we should be able to stop them.
Okay. Particularly when you are importing into the country.
We should be able to stop.
Suspected terrorists.
Do you find, since Honorable Inusa is still at it, do you find any safeguard, as looking at it from the perspective of a lawyer, I mean plainly looking at it, do you find any protection for legal privilege in this bill? It looks as if it is absolutely absent. There is nothing of the sort, so that the principles of legal privilege are going to be breached.
Inherent in the client-counsel relationship.
It's inherent.
It's inherent.
You think
I mean,
this doesn't breach the evidence decree?
At common law, the legal privilege is inherent. It is only when there is a law ousting your legal privilege that you can say that in this particular case, my legal privilege has
You want us to look at best practice. In the UK, where they are also looking at the same law, they have promised, okay, and one of these reports, let me read, it says, a new law governing official interception of communications will contain statutory protection for legal privilege,
yeah.
the Home Secretary has said.
Yes.
In fact, the Bar Council in the UK, well, and the Law Society were in arms with the state about all of these
aspects of conspiracy. Because lawyers too are human beings who have affiliations and associations who can use client-lawyer relationship to perpetuate crime. And so most of them hid under common law to advance the cause of what they believed in.
The outcry is
so what happened?
Is that the clarion call really is that no courts, no interception.
Yes, that's the clarion call.
No court, no interception.
Over there. That's the call.
And we want to say to be in Ghana.
Here too.
No court, no interception.
The first interception occurred 30 years ago. The law, 30 years ago.
Okay.
They are just building, you see, they have found lacuna. They have practiced the law 30 years. And they're saying that, well, I think that we need to put some safeguards. We don't have that law.
I see.
Okay? After Malon, so they passed this law.
So the simplest thing to do is to copy correctly from those who have had it.
That's what we've done.
No, you haven't done that. You see, I was reading. He said government wants to listen, tap, copy, record, and intercept your messages via the telecommunication system through the interception of postal packets and telecommunication message bill.
And tamper with.
Yeah, and tamper with. This is the basis of it. The simplest way you can talk about it. Now, the question is, what is it there? Is it to create ghosts so you can go after them and hunt them where there are no ghosts? And now...
Okay, I'm sorry, but we have...
talk about that
we have run out of time. Sorry, we have run out of time. Sorry about that. Sorry about that. My guests for this morning have been Kweku Bako Jr. He is managing editor-in-chief of the New Crusading Guide newspaper. Kofi Bentil is vice president of Imani, Ghana. Honorable Henry Kwabena Kokofu is a member of parliament. He represents the Bantama constituency. Okay. And then Honorable Inusa Fuseni is also a member of parliament, and he is the minister responsible for roads. Thank you very much, gentlemen. And as always, my outfit is provided by Latida. Have a good afternoon. We'll come your way next week. And next week, I will tell you more about the campaign I started for you to support that wonderful woman, to support the disabled and other people in the society. Thank you very much. Have a good afternoon.